Valuing and dividing deferred compensation, especially stock options, can be quite complex when it comes to divorce. And here to talk with us about that is Philip Hertzberg from Team Hewins. Philip, welcome.
Well, thank you, Bob. I really appreciate the warm invitation to speak about this topic.
Yeah, we appreciate you coming on to talk about it because it's something that I think a lot of married couples who are going through a divorce wonder about. So, where to begin?
Yeah, divorce is while it's emotionally draining, it also brings a lot of different financial challenges and decisions that have long-lasting impacts on both parties involved. So, valuing and dividing deferred compensation, especially the stock options, brings a lot of layers of complexity here. While it's wonderful employee benefit and a great way to build wealth, these non-cash payouts come with some intricacies and risks that many companies don't fully explain. So the financial instruments here, they can significantly affect the financial stability of both individuals post-divorce. So it makes it really important to understand how these assets are split up and the ramifications of such a division. So it's frequently problematic to discover these stock options as they don't show up on the tax returns on W-2 forms that are sent by the IRS or other financial documentations until the awards vest or exercise or are paid. So as a result, you're inclined to forget that you own the stock options altogether, and you'll leave this information out on the financial affidavit.
So, my understanding is that there are, what, four common types of stock options that folks need to know about?
Yeah, I mean, there are four different types that the companies tend to want to offer to attract and retain employees. First are the non-qualified stock options, abbreviated NQSOs. Then there's what's called the incentive stock options, or ISOs, for a newer employee. And third, there's what's called restricted stock. And then fourth is finally restricted stock units. Stock option compensation is often defined by the first two types, which are non-qualified stock options and the ISOs, the incentive stock options.
Do you want to walk us through some more detail on those different types of options?
Absolutely. The non-qualified stock options and the incentive stock options, they're variations of the stock options. They're not transferable in a divorce. A stock option is simply the right to buy the equity in the company that employs you at a set price, with profit potential if the stock prices rises and you decide to sell it after a certain time. So it's very typical to find in a private business with an initial public offering. They're giving employees an extra incentive to join the company that they might be able to offer the same as a mature organization would with cash compensation. So the employees here, before exercising the stock options, they got to follow what's called a vesting schedule, which means you have to work for the company for a specified period of time to buy the shares. So it can be risky if the value may be zero, if the market price is equal or less than what we call as the exercise or the strike price. So, the non-qualified stock options, they can add to your annual compensation. And as a result, they, increasing your work income, they also increase income taxes. In contrast, when we talk about the incentive stock options or the ISOs, they do not boost the income, but they may trigger other taxes such as alternative minimum tax.
So, my understanding also is that stock options and restricted stock are not the same. Is that correct?
Yeah, they are not exactly the same. The timing, value, and purpose of the stock options and the restricted stock are different from one another. So, in contrast to the stock options, restricted stock is stock that has been granted to an executive employee that's not transferable and subject to forfeiture under certain conditions. The conditions may be an employee, your employer may terminate you, or there's a failure to meet certain corporate or individual performance benchmarks. So restricted stock becomes available to the recipient under a graded vested schedule that lasts many years. And then when the restricted stock fully vest in the future, it becomes taxable, and the entire amount of the vested stock must be includable as ordinary income in the year of vesting. So shareholders of restricted stock, they're permitted to report fair market value of shares as ordinary income they're granted instead of when they become vested, if desired under a special election under the IRS code called an IRS Section B election. So why is this all important here? So as an employee spouse in a divorce, you can be betting that the stock price will subsequently appreciate after increasing your taxable income based on the current value of the asset, which is non-exercisable. So even though generally income will be overstated and taxes are higher in a divorce, you can actually benefit, being the employee spouse here, from the stock increasing in value later as an asset. So I wanted to also add here that restricted stock units, while having a lot of similar features with the restricted stocks, they're different in that they represent an unsecured promise by the employer to grant a specified number of shares of stock to the employee under completion of the vested schedule. So some plans may also allow for cash rather than stock at a future vesting date. So in the case of the restricted stock units, the RSUs, no IRS Section 83B election is permitted since the recipient has not received any actual shares until the year of vesting. So ordinarily, these RSUs are non-transferable in a divorce. A suggestion here for just overall for understanding stock options and compensation in divorce. If you really want to understand the full scope of your employer's compensation plan, you should obtain plan documents with what's called a summary plan description. Right there, you'll be able to, once you get that, and you also request award letters and information on the grants from your employers, you'll be able to see all the information that's needed, which include grant dates, number of shares, grant exercise price, expiration, and vesting schedule.
Yeah. So, given all the technicalities that you just went through, how does one ultimately, is there a framework for dividing and valuing all these assets?
Absolutely. So once you understand the types of stock options that you have and the compensation during a divorce, the next step here is to have a legal framework for splitting up the assets, and that depends predominantly on the state's laws where the division is filed. So states in the United States generally either follow the community property or what's called equitable distribution principles. So in community property states such as Texas and California, all marital property is divided 50-50. On the other hand, in what's called equitable distribution property states like New York and Florida, marital property is divided in a manner that is deemed fair and equitable, and that doesn't necessarily mean equal. In a division, stock options are considered marital property if they were granted before marriage and vested before the divorce date, making them subject to division. It becomes more complex when these assets do not vest until a date beyond the division and they're awarded for future performance. So clearly there's somewhat of a delineation between grants based on previous work and grants based on future work. Some of the complications that can develop here is an employee can receive a grant as a reward for past performance even after the date of separation, but it often is recognized as a performance bonus for work performed during the marriage.
A lot of ambiguity there, perhaps.
Absolutely. So what does this require you do? You've got to do some intensive fact verification, which includes obtaining access to the employee handbook, human resource employment letters, and all documentation that can reveal employees' motives for granting these awards. So once all these factors have been accounted for, your state can categorize the award as either marital or separate property. If classified as marital assets, you can then determine how it will be valued and the manner, as a non-employee spouse, you will be compensated.
So, I guess what the next question is it the strategies that you need to adopt here, Philip?
Yeah, absolutely. Once you have all this in place, you got and before going into the strategies, you got to make sure, once these assets are determined to be marital property, a value needs to be attached to them. So there was a lot of challenges with valuation, especially, since these aren't exactly marketable traded securities here. There could be fluctuating values and the conditions under which they're realized could create a lot of challenges. So that results in, very different taxable implications of their transfer or sale. So figuring out the fair market value can be very complex, especially for unvested options or if the company is not publicly traded. So here, several valuation methods are included or taken into consideration. So one of the common stock option valuation methods is what's called the Black-Scholes model. It can be used to estimate current values, and states generally vary on which method is generally acceptable. So just to drill down into some of the different planning strategies that can be considered and effectively employed to assets when considering dividing the stock options, you can have what's called a buyout, where one spouse simply buys the other share of the assets out, and this requires liquidity and may require some sort of financing in terms of the buyout. Second, what's often seen is just a deferred division type of a strategy, which is useful for unvested stock options. There's also what's called third, an equal distribution or sharing of assets, where simply assets are just divided equally according to a percentage that parties agree on. So this involves maybe splitting the investment portfolio or assigning certain options to each party. And fourth and finally, just simply selling and dividing the proceeds is the last stock option strategy division. And that often occurs if the division is too complicated, and both parties should agree that selling the assets and dividing the proceeds might just be the simplest option. So you have to be very mindful of the possible tax implications, and this may not be the best choice if the market conditions are not favorable. What's really important to also point out here, if none of these strategies are suitable whatsoever, the four different planning strategies just mentioned, buyout, different types of divisions, splitting of assets, selling and dividing the proceeds, there are alternative solutions out there. It is important, and I'd be remiss without saying this, for retirement investments, there's what's called a qualified domestic relations order, or what's called a QDRO, QDRO, which may be needed. So in the case of stock options and restricted stock units, this legal order can protect your rights and ensure an accurate allocation of these complex assets. So, in essence, a QDRO permits division of retirement benefits without penalties for an early withdrawal, and that ensures each party receives their shares directly from their retirement account. And there's also some other cases where assets do not have a certain future value. There's what's called a constructive trust, which can be created to hold and manage the assets until the value is realized, and the trust can then distribute the assets according to what the divorce agreement stipulates.
Yeah. So all kinds of tax and financial implications from what we've just discussed, yes?
Absolutely. And this is where, Bob, you need to see a trusted professional to help you bring clarity and help you give you confidence in what you're deciding upon. So each type of equity compensation brings its own tax ramifications and financial planning implications. So you have a choice, as does your ex-spouse, when you exercise your right to either cash out or buy the underlying stock. So that's one decision right there. So once the value is realized, you're going to be taxed for what's called the NQSOs, or the non-qualified stock options. You'll owe tax upon exercising before you have the liquidity created by selling the stock. So generally, the recipient of these assets is responsible for the associated tax. The tax burden cannot be transferred to the non-employee spouse. So you got to be able to sort of project the taxes that you owe in advance. All profits are taxed at the employee's rate. Shares are withheld to pay for taxes upon exercise. And if the proceeds are divided as part of the income, then the recipient of the spousal support will possibly owe taxes depending on the language of the agreement. So what's important here, going back to the professional, is you've got to strategize with a qualified CPA or tax professional who can analyze your potential tax liability, and then also even consider working with an attorney who understands the intricacies of these tax laws in this context. So with this type of tax counsel from a CPA as well as an attorney potentially, it may be it may be possible to minimize tax liabilities and maximize the net value of these assets. So you can take proactive steps here with professional guidance to cover the tax liability without having to sell an investment you otherwise would rather preserve.
Yeah. So I guess the final word, Philip, is working with a CPA, working with an attorney. It also would behoove you to have a quarterback at the helm, perhaps, too. Is that right?
Yep. And that quarterback and leader of the professional team is the Certified Financial Planning Professional, the CFP, who understands all the nuances of the equity compensation and can assist you in making sense of the complicated offerings. So a CFP professional can help you make informed decisions about how your equity compensation aligns with your life goals and risk tolerance. And then you can make informed decisions at every point, from when and how to exercise the stock options to the most tax advantaged manner to sell accumulated shares.
I want to thank you ever so much for chatting with us, for sharing your knowledge and wisdom with our listeners and our readers. It's so greatly appreciated. Thank you.
You're very welcome, Bob. I'm so grateful to you and the opportunity here to speak with you and many readers about this important topic today.